Welcome back to our channel. Now we are discussing on speculative home buyers. Supreme Court bars speculative home buyers from Section 7 of IBC. In a landmark judgment, Supreme Court of India has drawn a clear line between genuine home buyers and speculative investors under the IBC. The court held that the speculative home buyers who enter into the agreements with buyback clauses, assured returns, or investment style arrangements cannot be treated as allottees for the purpose of invoking Section 7 of IBC. This ruling protects genuine home buyers while preventing misuse of insolvency proceedings by the financial speculators. Key highlights of this judgment, we see the ruling: speculative home buyers cannot initiate corporate insolvency resolution process under Section 7 of IBC. The indicators of speculation is buyback clauses, abnormally high assumed returns like 20 to 25% per annum, contracts resembling investment schemes, not purchase of the property. The background of the case is the appeals arose from two NCLAT judgments that had branded certain home buyers as speculative investors. In both the cases, NCLT admitted Section 7 applications of the home buyers. NCLAT reversed, holding them to be investors, not genuine allottees. The Supreme Court upheld Honorable NCLAT's view, dismissing the appeals of home buyers. What is the legislative intent and amendments? 2018 amendment, home buyers were recognized as financial creditors to protect their interests. But what is misuse? Misuse detected. Some investors used this status to claim assured returns and refunds, distorting the law's intent. 2019 Ordinance Amendment Act introduced threshold requirement like minimum 100 home buyers or 10% of total allottees in a project must jointly file under Section 7. Supreme Court's view, this safeguard was necessary and valid to prevent speculative misuse. Court's reasoning: speculative investors defined enter into transactions purely for financial gain, have no genuine intention of taking possession of the property. Indicators. What are the indicators for speculation? Assured returns clauses, 25% per annum in one case, mandatory buyback obligations, agreements structured like investment contracts. We'll see legal precedents relied upon. Pioneer Urban Land versus Pioneer Urban Land and Infrastructure Limited versus Union of India. Another case, Binichand Rataria. And one more case, Jute Investment Company. These are the cases precedents relied upon. Applicability of 2019 amendment to pending cases. Doctrine of actus curiae leminem gravabit applied. Court held that compliance at appellate stage is sufficient. So the directions and broader implications, if you see, protection of Article 21, right to shelter reaffirmed as a fundamental right. Strengthening institutions, directions to improve NCLT NCLAT infrastructure. And if you see the role of RERA, encouraged enhanced RERA oversight in real estate disputes. And even the investors versus Allottee distinction. Genuine home buyers are protected as a financial creditor and speculative investors barred from IBC remedies. So the conclusion is the Supreme Court's ruling provides clarity and balance in insolvency proceedings involving real estate. So safeguards genuine home buyers, ensuring their voices are protected in CRT, and curtails speculative misuse, preventing investors from derailing projects for early financial exits. Harmonizes legislative intent of 2018 and 2019 amendments, reinforcing trust in the real estate sector and the IBC framework. So this decision marks a turning point for India's real estate insolvency landscape, ensuring that the Section 7 of IBC remains a shield for genuine home buyers, not a sword for speculative investors. We have two channels, RR Corporates, other channel RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of latest updates. Thank you.